This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Morning, Treasure Coast and beyond. It's Friday, time for Ask a Lawyer. Please feel free to give us a call at 340-1590. I'll try to answer anything I can, and there's nothing coming through the headphones.
Nothing coming through your
now it's fine. Now it's fine. Okay, technology. As the rabbi says, it's wonderful when it works.
Sure.
All right, so give us a call. You know, if any questions, any topic, I'll try to answer it. And if I can't, I will tell you that I don't know a thing about it. All right. I'll be honest.
Which really have not been too many times over the last year.
Oh, there's, criminal law and lots of, they're tax. Don't call me about tax law, folks. All right. Well, Cliff said on the last show that I guess Sunday is the first day of fall. I guess that means on Monday, PI attorneys are going to get lots of calls.
What?
Fall.
Oh, slip and fall. Okay, gotcha.
Ba-dum-bum.
Oh.
Where are the sound effects on this rinky-dink station?
Oh, man. Okay.
And, Cliff also said he doesn't like, getting faxes and cards. I was going to send him a card for Rosh Hashanah, but I guess I shouldn't now.
Yeah, well, cards are fine. I don't think we've had a fax in this station in 2 years.
Do you have a fax machine?
Sure, it's been hooked up, but I don't think anybody uses it. How many times do you actually fax stuff now?
I still fax stuff, but I do it from my desktop.
Okay, so it sort of functions as an email fax type thing.
Yes, sometimes when it needs to be faxed, it's half a dozen of one and 22 of the other.
Right. Yes.
All right, folks. So I have been trying a couple weeks to get to the second part of the Family Medical Leave Act. And who knows whether we'll do that this morning. Some of it depends upon your calls. And I'm also going to start with a little personal highlight, observation, update, whatever you want to call it. Because we did have somebody call last weekend and ask me about this. This past Monday was my last day in the intensive outpatient for the eating disorder clinic. They discharged me. I begged them not to let me go. But they told me the little bird has to be pushed out of the nest. Well, I don't know. I hope I fly. No, I was never told I could fly. So now they've set me up with, an outpatient therapist who's familiar with the ARFID eating disorder and a dietitian. I never thought I would ever like a dietitian. Got to admit. I mean, I have suffered with this thing for 58 years. I can't go on any diets because I don't eat anything. So whenever, a doctor would introduce me to a dietitian or a nutritionist, I'd laugh. I'd say, what's the purpose of this? It's not going to accomplish anything. And after listening to me for about half an hour, they all agreed. Well, the dietitian at the Center for Discovery became my best friend. She was phenomenal. Helped me to accomplish things I never thought I would accomplish. And we have John on line one. I guess he doesn't want to hear any more about this. Hi, John. How can I help you?
Oh, good. Good morning. I have a nephew that's working for a commercial landscaper.
Okay, nephew, commercial landscaper.
My nephew is working for a commercial landscaper. And he starts at 7. He's done around 4:30. Gets a half hour for lunch. But he told me that they do not allow the workers to take a break.
I've heard that before.
Is that legal? Is that
yes, it is. It is legal to prohibit or preclude or not give a break. I mean, unless you're in a certain regulated industry like trucking, where breaks are mandated every so often, there is no state or federal law which requires breaks. It's a common misconception. However, if as a result of not getting that break or not getting a lunch period, you go over 40 hours, in a situation, the type of job you're describing that your nephew has, he would most likely be entitled to overtime.
What happens to me then? What, entitled to overtime?
Right. If he goes over 40, he's most likely entitled to overtime.
Yeah. Well, he works 5 days a week from 7 to at least 4.
Right.
That's what, 8.5 hours.
Well,
roughly.
yeah, right. If he's not getting, if he's not getting the lunch hour, or lunch half hour, whatever, the lunch break, and he's not getting other breaks, he may very well be going over 40 hours.
Yeah.
So that's something to look at. The other thing to take, the other thing to remember is, if you talk to him, if he's getting lunch, is he completely relieved of all responsibility from work? Because if they ask him a single question on his lunch break, his entire lunch break is working time.
Yeah. This particular owner of this business, she's fire happy.
A lot of employers are, unfortunately.
Yeah, well, she's really something. If you come in late one morning, then you have to lose it the next day off.
Well, I mean, there's nothing that makes that unlawful. Employer wants to be a jerk. They can be a jerk. But if your nephew decides he wants to inquire, notice I'm not using the word complain. I'm using the word inquire about overtime. I would definitely suggest he do it in an email, some form where it's proof that he made the inquiry, because if she then turns around the next day and fires him, he's protected from retaliation because he can prove he made the inquiry.
Okay. I wanted to tell you that about dieting. I've had a problem all my life. I've been up and down. I went to a workshop. I wanted to say diet workshop, but similar to that.
Right.
And well, I went there to get a little information, and then I came back to sign up and become part of the meetings. And when I went back, they had pizza and cupcakes. And I said, "What's this?" They said, "Oh, it's our first-year anniversary. We're celebrating."
Well, that sounds odd, and you're laughing, and I understand why you're laughing.
Well, I didn't go back.
Well,
I tell you what happened. I was mentally ready to diet, and I was really psyched. And I joined a diet workshop, and over about an 8-9 month period, I had lost over 100 pounds, 100 plus.
That's pretty good.
And I kept up for about 5-6 years. My biggest problem was I didn't stay with the meetings.
Well, that's what happens, and you start gaining weight back.
Yeah, I could have stayed the rest of my life for free because I had reached my goal.
Right.
And all that good stuff.
Well, thank you, John, for calling. Okay. I appreciate it.
You know what the Moyle said?
What's that?
It won't be long now.
It won't be long now for what? Nuclear war?
The Moyle. Now I got to go. I've got an appointment.
All right. Bye-bye, John.
All right. Bye-bye now.
Anyway, I'll tell you something. John was chuckling a little bit about going to some kind of diet meeting. He didn't say which company, so it's okay. And they had pizza and cupcakes. They said it's their first anniversary. And that sounds really absurd, doesn't it? But I will tell you that after 4 months at an eating disorder facility, they don't view any food as bad food. Okay? There is not good food and bad food. There is food that you eat in moderation. If you try, their perspective is, it's called intuitive eating. Their perspective is that if you try to deprive yourself of pizza and cupcakes, you're never going to keep weight off.
But cupcakes are all sugar.
Doesn't matter. If you have one cupcake every 2 weeks, that's fine. If you tell yourself you're never having a cupcake again, it's not going to work. That's their perspective. And I can see some merit in it. There are some diets that say, okay, Sunday's cheat day. what they're really saying is, here's a funnel for you to let off steam.
Yes.
But when you assign it to one day, what happens if you go to a fair on Thursday night? You're not allowed to touch anything? So the way they look at it as, and of course every eating disorder is slightly different, but they're overriding the dietitian's principle is that there is no food that is good or bad. There is food that is healthier, and there is food that should be eaten more often than other foods, but that if your favorite food happens to be cotton candy, not really a food, but if your favorite dessert or your favorite snack happens to be cotton candy, don't tell yourself you're never going to have cotton candy again. Tell yourself that instead of having cotton candy 3 times a week, you're going to have it once every 2 weeks. Then you might be able to manage. It's their perception.
It's intriguing. Okay.
And after 4 months of going through these nutrition groups, which I hated, because for my particular eating disorder, they were really irrelevant.
Because you didn't like a lot of the
right.
food.
It's like I didn't care what the nutritional quality was. I just wanted to eat more foods. And I told them that, and they understood. They knew I hated those nutritional, group sessions. I just didn't think they were relevant. I don't care how a carbohydrate breaks down. I just want an extra, 20 foods in my repertoire. So, but anyway, to try to quickly highlight, I'm out of that thing now. And the interesting thing is I'm out not because the insurance company cut me off. If those of you who are listening will remember that back in May, the insurance company decided I wasn't covered, and I had to fight them. I lost 2 appeals, and then I filed an external appeal that went up to Maryland, and they were utterly reversed and overturned. And so this time, when I was discharged, it was because the center decided it was time. And I was much more willing to accept that decision. Anyway, we have Jerry on line 3. Hello, Jerry. How can I help you?
Good morning, gentlemen. I worked for General Electric back in 1977. I was pretty young, and they flew 6 of us from Michigan to New Jersey.
Why would you want to go to New Jersey? I grew up in New Jersey.
What?
Why would you want to go to New Jersey? I grew up in New Jersey.
Oh, I love New Jersey.
What
I'm
exit?
from Michigan.
What exit?
Pardon me?
What exit?
It was the Oyster Creek Nuclear Generating Station.
Okay.
Yeah. What toxic waste dump was that off of? Oh.
You know what they told us? They
Top
told
of the
us we
Superfund list.
Yeah. Well, anyways, they told us we were in a place called Waretown. All we knew is we were working at the Oyster Creek Nuclear Generating Station. And when I got back to Michigan, all the time we were in New Jersey, there were 6 of us. We all had an expense account, and we were just workers. We weren't executives or anything like that. And so I was really young. I was only 23 in 1977. And when I got back to Michigan, some other worker told the foreman that I told him an ethnic joke, a Polish joke, and I don't tell ethnic jokes. And so the foreman was Polish, and he went to the supervisor, and I got fired. And I just wonder if I'd like to listen off air, but I just wonder if you could talk about that scenario and what a young worker could do in a case like that.
I will do that, and thank you for calling.
Okay.
All right, the question is, back in 1977, he was working, and somebody said that he had told an ethnic joke, and his supervisor was Polish and wasn't happy, and I guess he got discharged.
Got this great Polish joke. Oh.
And he wants to know what could a worker do in that situation? Nothing.
Oh, great.
All right. Here's the concept of at-will employment. Most states now in this country are at-will employment. There are some states that have carved out some exceptions and are better. Florida is horrific. At-will employment generally is, unless you have a contract that says that you can only be terminated for cause, then an employer may terminate you for no reason at all, a good reason, a bad reason, a fair reason or an unfair reason, a factually correct or incorrect reason. So, if some guy says you told an ethnic joke and you didn't and you get fired for it, you have no claim against your employer if you're an at-will employee. Now, you may have a defamation claim against the coworker who said you told the ethnic joke if he can't prove you did it. But against the employer, nope, nothing. And that sounds horrific. It sounds unfair. I agree. But that is at-will employment in the United States of America.
It's also GE.
I'm
sorry.
And as I say, there are some states that have carved out exceptions. For example, a public policy exception. You're an at-will employee, but we won't let an employer terminate you for something that violates public policy. Okay? There are other states that have even other exceptions that they've grafted onto that by statute. Florida has no exceptions. Florida is a pure at-will employment state. So unless you have a contract that says you're only going to be terminated for cause, the only protection you have is against the employer taking adverse employment action, whether it's a suspension, a demotion, termination, for an illegal reason. And that means a reason that violates a state or a federal statute. Most common is discrimination under either the Florida Civil Rights Act or Title VII of the Federal Civil Rights Act, on retaliation for that. Workers' compensation retaliation, whistleblower retaliation. Those are perhaps 95% of all the exceptions to at-will employment in Florida. There's always going to be a few others somewhere, but that's basically it. So if it's not one of those things, you're an at-will employee. If you don't like the terms of employment, you can leave or be fired. If somebody says something that's not true, tough luck. We have gotten several calls over the years from cashiers who, at the end of a shift, they count out the draw, and the boss says, "You're short.
Oh.
You're fired." Later that night, when they do their audit, they find the money. So
but they've already fired the person.
They've already fired the cashier.
Oh, God.
But in reality, she wasn't short. So I get a phone call. I've had 3 of these, I think, over the last 18 months. Can I get my job back? No. Unless the employer wants to give it to you. But no, you have no right to get your job back. You have no right to sue. But they were wrong. I know, they were wrong. And they should give you your job back, but no requirement to do so.
Did any of those people wind up getting their job back?
I don't know because
yeah,
I don't. If they didn't, I probably wasn't going to hear from them again because I told them they have no case.
Right.
If they did, they're not going to call me and tell me I got my job back.
Right.
So I don't know. So if anybody's listening and you got your job back, call me. But that at-will employment is a problem. But it's the way it is. Now, for those of you who are listening, who are going to say, no, Florida's not an at-will state. It's a right-to-work state. Guess what?
That's what we talked about.
You're right, too. It's an at-will state in the context of the right to discharge. It is a right-to-work state in terms of the right to form a union. 2 very different concepts. The reason for the confusion is that in the olden days, when not every state in the country, except I think 1 now, was an at-will employment state, how they differentiated the states was some states were called at-will, some were right-to-work. In that context, right-to-work meant you had to have cause to be discharged. But since that's essentially disappeared from the American landscape, now at-will is basically what you are, and right-to-work really relates to union rights. I thought
that was a closed union state like California and versus
that's
open like Arizona.
Right. And now in unions also, keep in mind, you may not have a written contract with your employer, but if you're a member of a union, the union probably does. And that may give you certain rights that expand your protections beyond the traditional at-will doctrine. So sometimes when we get a call from people that say, well, there's a union, so have you talked to your union folk about whether you have protections, whether you have the right to grievances, whether they'll represent you? No, not yet. Well, I think you should do that first. Sometimes we're told, but I don't belong to the union. Guess what, folks? It doesn't matter. Most unions are contract on behalf of the entire bargaining unit. And even if you choose not to join the union, you're considered a member of the bargaining unit. So you have rights under the union contract. They may choose not to represent you because you chose not to join the union. But it doesn't mean you don't have the rights that they collectively bargained on behalf of the entire bargaining unit.
But there is no choice in, say, Los Angeles, at least with our union. You cannot get a job unless you're in the union.
Different states
after it.
Right, different requirements.
And so it was one of those things that, luckily I had already joined the union in Boston and could slide into Los Angeles and work there. But yeah, if you were not a member, you didn't get the job. And
so that's a little bit more of another topic we had covered a couple times over the last year and a half, at-will employment. So I will move on to family medical leave from my own eating disorder thing, but let me just say one last thing. I've realized there are a lot more people out there that have one form or another of an eating disorder than I ever imagined. I saw a lot of things there, a lot of generally women with different types of eating disorders, some younger, some older, some very young, which broke my heart. But if you do, or if you know somebody who does, there really is help out there. And I can tell you that the folks that I dealt with at the Center for Discovery were truly wonderful. They had my best interest at heart. Sometimes I was not exactly the most cooperative. When you have a fear of certain foods and they suggest trying something, they call it an eating disorder voice. The eating disorder voice yells and screams, no, 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 it's dangerous, don't try it. Getting through that has been impossible for me on my own. With them, the progress I made in trying new foods over 4 months, I've tried more new foods in 4 months than I've tried in 50 years.
Wow.
Now the task is getting to eat them on a regular basis so that they don't just become something I tried, but they become something incorporated into my repertoire, which is what the outpatient dietitian and therapist is for, to make sure I don't backslide. But if you know somebody with an eating disorder, or you have one yourself, look into getting some help. I mean, there's different levels of care. There's pure outpatient, there's intensive outpatient where you go a lot, there's partial hospitalization, and there's inpatient. All depends upon the circumstances and the insurance coverage.
Sure. Hypothetically, if you do start to slide and the therapist sees that, can they reel you back in?
They can. If the recommendation, I guess, was made to the insurance company by the outpatient support staff that he needs more help than he can get on the outside right now, then I guess I could probably get more IOP, intensive outpatient, for a shorter period of time. The goal, of course, look, there were people there that said, well, this is my 7th time. Now, not necessarily at that facility. Some had gone other states, some had gone partial hospitalization, some were in residence, and now they're here. But there are people 7th time, 8th time. I mean, I learned to understand it. In the beginning, I could not understand it. But an eating disorder is a very difficult thing to kick. I mean, the top ones are anorexia, bulimia, binge eating disorder.
Those are the ones you hear about.
Right. You don't hear about ARFID because ARFID was really just created 5 years ago. Now, I had it since I was 58 years ago. So nobody could figure it out because nobody understood it. Nobody knew what it was. We were talking 5 years from now, the treatment for ARFID will be radically different than what I have. Just look at how iPhones change every year. 5 years from now, they will have a much different treatment protocol for my particular eating disorder than they do now, because they're baby steps right now. But those baby steps help me take giant strides. So I would just say, honestly, to anybody, if you have it, if you know somebody, any type of an eating disorder, don't live with it. It's the enemy. It does such damage. There was one young lady there who had done such damage to her body that her digestive system was never going to be the same. It was never going to be repairable. She was going to have lifelong problems, and she was in her 20s.
Oh, God.
Okay? These things are insidious. And as a result, I'm actually writing a book. At first, they thought I was joking there, but then I started giving them chapters.
Really?
Yeah. So
Okay.
they realized I was serious. The working title right now is 60 Years with ARFID, One Man's Journey to Recovery. Because I've noticed when you Google, go to Amazon and look up eating disorder books, there's plenty of them. First of all, there's only one on ARFID. So another one, there's certainly space for it. There are some books written by those with eating disorders, not a lot. And there is virtually no books, one or two, by people with eating disorders having written a book where the person with the disorder is a male. And that's not because men don't suffer from it, it's that men don't come out and admit it.
Well, yeah.
So
We don't do that too easily.
one written by somebody like me, maybe that'll help somebody else. And, there are a lot of people that take negatives in their life, try to turn them into some kind of a positive. There are kids that were part of the horrific shooting at Stoneman Douglas, and we all know what they did. They lobbied for gun control legislation. They stormed the Capitol in Tallahassee. They got meetings with the governor. They took a tragedy and tried to get something positive out of it to help others in the future. And a lot of people do that. Every time you hear of Megan's Law or somebody's law, that's because some parents decided, I lost my kid. That's horrific. I'm never going to get over it. But I'm going to try to do something to ease the pain and make it better for somebody else in the future. So I'm going to write a book, and maybe that'll help somebody down the road.
Coming soon to Amazon.
Coming soon to Amazon. Who knows how soon, but, I've never written a book, and so I assume if anybody is interested, they'll have to give me an editor. They'll tell me how to rewrite the dang thing, and who knows when it'll be ready. But I already have 13,000 words.
Wow.
So I'm going. I'm serious.
Published by Simon & Schuster, a CBS company. Oh.
All right. Family and medical leave. We've talked a lot about it. So we're going to get into some areas that we may have discussed a year ago, but not more recently. And I have had 6 calls on the FMLA in the last 2 weeks.
Wow.
So this is actually fairly timely. All right. We talked about your rights to FMLA and under what circumstances you have rights and how many employees the company has to have, how long you have to work there. If you didn't hear that and you really have those questions, either give me a call here or call my office at 781-8003. Don't ask for Cheryl. Cheryl's not there anymore. We have just hired a new paralegal. She will start in a couple of weeks. She had to give notice to her judge.
Ooh.
Yes, we poached somebody from the bench.
A high-powered paralegal, yes.
So somebody who can give me some insight on what it's like on the other side of the bench. What is the judge thinking? What is the judge looking for?
The dark side.
That's right. So pretty soon I'll give you a name, and you can call and say hello to her and harass her, and she'll get a baptism of radio calls. All right, but notice, you're going to take time off. You've been approved for FMLA. You still have an obligation to give the employer reasonable notice. Generally, that's considered 30 days at least. Now, what happens if you can't give 30 days notice? What happens if there is something, an illness changes course, and now you've got to run to somebody's bedside? Not your own, or maybe a family member. What happens if you were approved for intermittent leave as needed? In those situations, you don't have to give 30 days notice. What you have to do is give notice that is as reasonable as the circumstances dictate. Now, what does that mean? Lawyers will always argue about what does this mean? Well, luckily there's case law that helps us figure it out. If you know that next week you've got to go into the hospital for a follow-up biopsy, you should let your employer know a week ahead of time. If you let them know a day ahead of time, you might find yourself fired, and they would not be violating the FMLA. If you have intermittent leave, let's say your spouse has cancer and they're undergoing, chemotherapy or radiation or whatever other kind of treatment, and they're at the point where it's not every Monday, Wednesday, and Friday, but when things flare up, that you've got to get them immediately in. So you wake up one morning and you have to go to the hospital. You got to go to the doctor with your spouse. That virtually no notice, that's okay. If you've already been approved for intermittent family leave and you give that kind of virtually no notice, but because the situation necessitated it, you cannot be retaliated for it. But the overriding principle is, even though you were approved for family and medical leave, whether it's block leave for a certain period of time or intermittent leave, you need to give the best notice you can. And if you don't do that, then you're going to find yourself on the wrong side of a termination, and you're not going to have much you can do about it.
Got a question.
Go ahead.
Got a friend in California, National Guardsman, who, everything was fine with his employer, but then they were sent to Afghanistan. And when he came back, didn't have a job.
Now, I know there is a separate law that covers that. That's not FMLA. As a service member who is activated, I'm certain, because I've heard of it, but I don't know what it is. There is a law that protects service members who are activated and have to go, to an area of conflict. They don't say overseas because it's not always overseas, but an area of conflict as declared by the State Department, and they have certain rights to their positions in private employment when they come back. I don't know exactly what those rights are. I've actually never handled one of those situations, but like most lawyers, when you handle situations that are somewhat close to something else, you jump on Lexis or Westlaw, you look at the statute, you review some cases as to the particular facts that somebody presents to you, and you either give the best opinion you can if you think you've been able to adequately understand what the law is, or you say you need to go to somebody who's more of an expert in this area because I'm not sure I can give you the correct advice. And the best example of that, to deviate once again from FMLA, is I had a college roommate way back in good old 1988 or 89. This was after I was out of college, of course, when I was a lawyer. And we were out, pubbing, as they say, one evening. And both of us were a bit inebriated. And he was driving. So he was a little bit less inebriated, I thought, than me. So we drove to my house, and he was going to stay over, obviously. He lived 2 hours away down in South Jersey. And we got into an argument. So he said, I'm going home.
Oh, no.
And I said, what are you, crazy? You're drunk. Well, he went home. Back in those days, you didn't have cell phones. You had answering machines. I woke up the next morning, and my red light was blinking. And I had several messages from, this is the Highland Park Police Department. We have your friend, blah, 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 here at our facility. He'd like you to come bail him out.
Oh, no.
He got about a mile from my house to a sobriety checkpoint, because this was in the area. This was at Rutgers.
Oh, sure. Know exactly where it is.
He did not see the checkpoint.
Oh, no.
He drove right through it.
Oh.
And he almost ran over the chief of police's foot. So somebody jumped in a patrol vehicle and chased him a couple blocks when he pulled over when he saw lights. He failed the sobriety checkpoint.
You think?
He was arrested. I bailed him out. And then he says to me, I said, you have two choices. You can hire a DUI attorney who that's all they do and they know the law in and out. Or, I'll do it for you for free if you want, but I don't think it's a good idea. He said, I'd rather you handle it. All right, well, I learned as much as possible as I could. But I certainly was no expert. Now, I'm not going to go and brag about the results of the case. The point of the story is, he was in Air Force intelligence at the time. And I'm trying to figure out, because he asked me, do I have to report the arrest to my commanding officer? Because if you have to and you don't, you're going to face a court-martial. If you don't have to and you do, you're stupid. So the question is, do I have to report this arrest based upon his security clearance? So good old me goes into the Code of Federal Regulations, where it deals with this, and I can't make heads nor tails out of what it's saying. Under these circumstances, you must report. These you must report within 48 hours. These you don't have to. And it was, the way Code of Federal Regulations is written, particularly Department of Defense regulations, I simply could not make heads or tails of it. I could not give him advice. Fortunately, when I was in law school, our Dean of Career Development was the former Navy JAG.
Ooh, okay.
Not a JAG, but the JAG.
Okay. Oh, the JAG.
The Judge Advocate General.
Wow.
And so I called him. And, I said, look, I have this situation. I explained it to him. I need to know whether he has to report the arrest or can he wait to see if he's convicted. And if he's convicted, does it matter what he's convicted of? And, of course, the JAG knows the answer right off the top of his head. I'm spending hours in the morass of DOD regulations.
He had it in 10 seconds.
He says to me he does not have to report the arrest for DUI. It was off-site. He wasn't active at the time. However, if he's convicted of DUI, he needs to report it immediately, and he's probably going to lose his security clearance. If he doesn't report it immediately, he's going to be court-martialed.
It's because of potential blackmail, I'm sure.
All right. I said, what about the next charge now is reckless driving? Same difference. The least that he could have been convicted of, which never happened in New Jersey at that time, was careless driving. He said, no, if he's convicted of careless driving, he doesn't even have to tell them. Okay. I had my marching instructions. So in the end, we get to trial, and I show the state attorney a video of the officer giving my client instructions on how to do the exercises, how to touch your nose, how to walk in a straight line. And from my perspective, the officer failed on several of them. He didn't walk in a straight line. He touched his nose. He touched the side of his nose. So I was told the state attorney, I'm going to argue that, if my client was drunk, then I guess your officer was drunk.
Oh, no.
I said, so can we deal with this? So he comes back and he offers me reckless driving. And I explained to him why I can't accept that. And I said, what about careless driving? And, back then, I don't know about now, but back then, the DUI, they had like a 99.9% conviction rate. Careless driving, that's not going to happen. Fortunately, he goes back and comes back to me and he says, the cop says that your client was very polite and respectful when we pulled him over. He didn't tell us until after we had booked him that he was in the Air Force. If he had told us, we would have just called the MPs and had them take him back to dry out, and he would have been fine. But once we started the process, we couldn't stop it. So since he was respectful, and we would have given him a pass anyway had we known he was military, we'll agree to careless driving.
Wow.
So he gets convicted of careless driving. He gets the drunk driving penalties we agreed to. And he walks out of there not even having to report the arrest to the Air Force. Now, that's an example of Sometimes an attorney can figure it out, or sometimes an attorney can know where to go to find it. But if you can't, you better tell your client to go get an expert, because otherwise you're going to screw it up.
Wow. That's an amazing story.
You know, as Paul Harvey would say, that's the rest of the story.
Wow.
All right, so where are we going to go from here? When you come back from FMLA, that's always a big question. What are your rights? Your rights are to be returned to the same position you left, or a substantially equivalent position. Now, substantially equivalent is in quotes because it has a meaning in the law. It's not what you think it is, it's what the law says it is. Substantially equivalent is a position that has roughly the same duties and responsibilities, authority, seniority, opportunities for advancement, bonuses, certainly salary. So if they don't have your position open, because they had to fill it, and it happens a lot of times, they got to get you another position that is roughly the same. If they do that, they've complied with the law. Now, what if you are a loan officer in a bank, and you come back and they make you a teller? No. That's not a substantially equivalent position. I know because I tried a 2-week federal case on it and won. How they argued it was, I don't know, but they did it with a straight face. That's what Palm Beach lawyers will do for you. Also, if you come back and all of a sudden you think you're starting to be treated differently, is that retaliation? It might be. Or it might be subtle enough that nobody's ever going to be able to prove it. And that's the practical reality of life. However, there are plenty of employers that are stupid and they keep us lawyers earning a living.
Really busy, yes.
You know, if, for example, in the teller situation, if you've been working for that bank for 10 years and have never been written up and have always had stellar reviews, and you come back, they make you a teller, and within 30 days you're written up 5 times and then terminated. That's a little suspicious. And then when you find out that 4 of the 5 write-ups for your drawer being short were inconsistent with the company's own policies that you don't write up tellers if the amount under or over is less than, let's say, $5. And you were. Somebody's out to get you.
Now, would the laws be any different if it was, say, a state bank versus a federal bank? It's all okay.
As long as it's a private employer. Public employers have different rules.
Okay.
You work for the state of Florida, you're going to have slightly different rules attached to you. But private employers, you know, that's the way it is. It's amazing, again, how many attorneys don't know things because they don't practice in that area, but then they try. I sent a demand letter this week to a company, a local company, alleging violations of the Florida Whistleblower Act and demanding a certain amount of money. And I get a response from an attorney citing the whistleblower statute, showing it to me and saying, your client did not comply with this section of the statute, and so I don't believe he has a claim. And what this attorney gave me was the Public Employee Whistleblower Act when my client worked for a private employer. So I write back to him with a copy of the statute, and I say, I think you have the wrong statute. Under this statute, we don't have to do what you said we didn't do. And under this statute, doing what we did is enough because it spells it out in subsection 3 of the statute. Get back to me.
Oh, yes.
You know, the person who is being represented by that attorney is at a disadvantage now. Because now I don't have a heck of a lot of respect for their counsel. And that may result in a slightly different settlement, if there is one. Or we may go to litigation if we have to. Now, I will admit, sometimes that happens to me too. So, you know, this statute, he said it's a complete wrong statute. But no attorney is immune from making a mistake or not knowing everything. When I deal with overtime law, There are 3 primary exemptions where you don't have to pay overtime. And those 3 exemptions account for 93% of all overtime cases. But there aren't just 3 exemptions under the statute, there are like 200. So what about the other 197? You think any attorney knows them all by heart? Not a chance. So on occasion, I will send a demand letter on an overtime claim, and I will get a letter back, but what about this exemption? And I'll go pull the books out, I'll find the exemption, I'll research the exemption, I'll say to myself, oh, the exemption applies. My clients aren't really entitled to overtime. Okay, I have a lot of egg on my face in terms of that attorney having pointed it out to me. I go to my client, I explain the situation. Sometimes they're okay when they understand, sometimes they're not okay, and that's the way it is. But it happens to everybody. The question is, does it happen when you're dealing with something where you can't know everything, or does it happen where you clearly don't know anything about the topic, but you're trying to represent somebody? I think that's a significant difference. But so you do have the right to go back to your job or a substantially equivalent job, and if they return you to a position where you don't have the same salary, or you don't have the same benefits, or you don't have the same opportunities for advancement to move up, or bonuses, then you need to talk to a lawyer, because you may have been retaliated against under the Family and Medical Leave Act.
If you were on a fast track, say, to be a manager,
okay,
and then they treated you like this, that seems like that would be kind of a patent violation.
Oh, absolutely. Now I get calls all the time about there's an area where there's a technical violation. And what does a technical violation get you? Damages if you suffered any, but usually you haven't suffered any. And I mentioned this before. I've mentioned this several times because it's so important to me. The Family and Medical Leave Act is unlike any other federal statute that protects employees that I know of. It doesn't require you to go to your employer and say, I need Family and Medical Leave Act time. If your employer learns of a situation that they think you might be subject to the rights of the Family and Medical Leave Act, they have to give you the federal packet. And up to you to decide whether you want to complete it. But they have to give it to you. If they know, for example, that your husband just got cancer, and they don't give you that packet, they have violated the FMLA. It is a technical violation not to have affirmatively provided you with the federal packet and to have advised you of your rights on the FMLA. Employers don't have to do that with other situations. If you're being sexually harassed and they find out about it, they don't have to tell you you have the right to make a complaint to us and then we have to do something. But if you don't complain, then we don't have to do anything. It's up to you to figure out, complain or don't complain. The FMLA is not like that. The employer has the obligation to get you that packet. If they're in the lunchroom and they overhear conversation, can you believe that June's husband, now has liver cancer and he's going to be going for chemo and radiation? That employer now has a duty to call you in or to have a supervisor call you in and offer you that written packet of documents and say you may be entitled to FMLA leave. If they don't, you got a violation. So we do get plenty of calls, and sometimes if there's a technical violation, we can get it fixed quickly. And you get your leave, and that's really all you really care about.
Is that like a letter situation usually? Okay.
Yeah, very often if it's pointed out to the employer, first we say, why don't you try because it's less hostile. And once you do it in writing again, you're protected from retaliation. I always tell people, folks, do it in writing. Really, do it in writing. Do it all in writing. If you have a situation that you need to complain about, okay, I understand if the first person you go to is your supervisor and you go, one-on-one verbally, that makes a lot of sense. But if you need to go higher, like to human resources or to a higher supervisor, send an email if you have company email. Or send a fax. If you have to, from Staples, Kinko's, whatever. Have a writing so that you can prove you complained. Or to use another word, if you don't want to complain, that you're advising them of the situation, asking they look into it. That written communication is important. You have rights without the writing. But many lawyers, including myself, will be much more hesitant to accept a case, discrimination, FMLA, whatever, if we hear that, oh, I complained several times verbally, but there's no writing. Because I know what the employer is going to claim. It never happened. Now, sometimes we can prove it did. Witnesses, what have you. But it's much more difficult. And so when you're evaluating whether to take a contingency fee case, you're looking for that writing. I told somebody just this week, did you put it in writing? I said, look, why don't you put this in writing, and if they don't handle it properly, call me back again. Because I wasn't interested in the case unless there was a writing. So, moral of the story, if you got a problem on the job, it doesn't have to be a hostile writing. It doesn't have to be long or fancy. It could be 2 sentences. I think that I was entitled to overtime this last paycheck. Could you please look into it? That's simple. It's polite, and you're protected. So please, I can't tell you, I get more calls without a writing than with a writing. And I harp on it. I really harp on it because if we're in a trial, it could be the difference to a juror between winning and losing. All right, so we are just about out of time. We have a little bit more FMLA and then a little bit going into the Americans with Disabilities Act. I guess that'll probably come next week. So for now, if you have a problem, call my office, 781-8003. For now, I will try to get back to you as soon as possible. If you get the voicemail, please leave a message. And have a good weekend. Hopefully it won't rain. And until next week, have a good time. And hopefully you don't need to ask a lawyer, but if you do, I'll be here next Friday as well. Bye-bye.
You've been listening to Ask a Lawyer right here on WPSL, Port St. Lucie, WPSL.com, webcaster to the world, on Alexa and Google Home.